Many recent cases in Act product liability have focused on injuries or illnesses attributable to toxic waste or other hazardous substances that were legally disposed. Because plaintiffs need not to demonstrate negligence or fault, these suits frequently succeed. Not surprisingly, the number of such suits promises to increase. Property law. As the name implies, property law concerns property rights. But what exactly is property? Is it the land under a house, the house itself, a car in a driveway, a dress in the closet? The answer in each case is yes. In the legal sense, property is anything of value to which a person or business has sole right of ownership. Indeed, property is technically those rights. Within this broad general definition, we can divide property into four categories. We define these categories and then examine more fully the legal protection of certain kinds of properties, intellectual property. First of all, the tangible real property. It is land, anything attached to it, a house, a factory, are both tangible real properties, as are built in appliances, the machines inside the buildings. Tangible personal property is any movable item that can be owned, bought, sold, or leased. Examples are automobiles, clothing, and stereos and cameras. They are also the property, the tangible personal property. Then there are intangible personal properties, which cannot be seen by but exist by the virtue of written documentaries. Examples are insurance policies, bank accounts, stocks, bonds, and trade secrets. They are, in fact, the intangible personal properties. Protection of intellectual rights. Intellectual property is created through a perception, creative activities, books, articles, songs, paintings, screenplays, computer software are all intellectual properties. The US Constitution grants protection to intellectual property by the means of copyrights, trademarks, and patents. Copyrights and patents apply to the tangible expressions of an idea, not to the ideas themselves. Thus, you could not copyright the idea of cloning dinosaurs from fossil DNA. Michael Crichton could copyright his novel Jurassic Park, which is a tangible result of that idea, and sell the film rights to the producer director Steven Spielberg. Both creators are entitled to profit, if any, that may be generated by their tangible creative expressions. Copyright. Copyrights give exclusive ownership rights to the creators of the books, articles, designs, illustrations, photos, films, and music. Computer programs and even semiconductor chips are also protected. Copyrights extends to the creators for their entire lives and to their estates for 70 years thereafter. All terms are automatically copyrighted for the moment of creation. Trademark. Because the development of the product is expensive, companies must prevent other firms from using their brand names. Often they must act to keep competitors from seducing consumers with similar or substitute products. A producer can apply to the US government for a trademark exclusive legal right to use a brand name. Trademarks are granted for 20 years and may be renewed indefinitely if a firm continues to protect its brand name. If a firm allows the brand name to lapse into common usage, it may lose protection. Common usage takes effect when a company fails to use the symbolic when the company fails to use the symbol to indicate that its brand name is a registered trademark.